Hello everyone, I'm Apurva Pandita and you're watching Live Law. As is very clear from the title of the video itself, today I'll be talking about a very interesting question. So can a private individual make an arrest? The idea of a private individual making an arrest may seem like something out of a Bollywood action movie, but it is actually a real and valid concept under Indian law. While police officers are primarily responsible for maintaining law and order, private individuals in India are authorized to make arrests under certain circumstances, meaning that you can also make an arrest. According to Section 43 of the Code of Criminal Procedure, that is CrPC, any person, including a private citizen, may arrest another person without a warrant if the person to be arrested has committed a cognizable offense or is reasonably suspected of having committed such an offense. This means that if a person witnesses a crime taking place or has reasonable suspicion that a crime has been committed, they have the power to make an arrest. However, this power comes with certain conditions. Only under these specified conditions can a person make an arrest. So let us now look into the law itself. What does Section 43 of the Criminal Procedure Code say? There are conditions given under this section under which anybody, including you and me, can make an arrest. First is the person making an arrest has either himself witnessed a crime taking place or has reasonable suspicion that a crime has been committed. So does this mean that if I witness a crime being committed, I can make the arrest of the accused? Well, yes, but only when the offense committed is a non-bailable and cognizable offense, which brings us to our second condition. That is, the crime committed must be non-bailable and cognizable. Now let us understand what exactly are non-bailable and cognizable offenses. So basically the criminal law classifies certain offenses as non-bailable and cognizable. This is because they are generally considered more serious in nature. Non-bailable offense is an offense for which bail is not a matter of right and the accused has to seek bail from the court, which means that the accused may or may not be granted bail after the arrest. The decision to grant bail in non-bailable offenses is left to the discretion of the court. It is important to note that not all non-bailable offenses are cognizable and not all cognizable offenses are non-bailable. Now coming over to the cognizable offenses, cognizable offense is an offense for which a police officer can arrest a person without a warrant and start an investigation without the court order. Some examples of both cognizable and non-bailable offenses include murder, rape, kidnapping for ransom, drug trafficking, acts of terrorism, etc. However, these are not all. I have only mentioned a few of these offenses. So now coming over to the third condition which needs to be followed is that the arrested person must be handed over to the nearest police officer or taken to the nearest police station immediately after the arrest. After handing over this person, it is the responsibility of the police officer from there on. So these were basically the three things which need to be kept in mind while any private individual makes an arrest. While the idea of a private individual making an arrest may seem thrilling, it is important to remember that it is not something to be taken lightly. Making any arrest can be dangerous and there are potential legal consequences for making an unlawful arrest. That was all for today's video. If you like our content, then please like and subscribe to our YouTube channel. And for more such interesting legal topics, keep watching Live Law.